Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. In today's video, we're in session number 4 of our new series entitled The QME Forensic Super Sleuth. The Forensic Super Sleuth. And let me ask you, as a qualified medical evaluator, did you ever think it would be required that you be a forensic super sleuth? Well, the philosophy of this program is that it is part of your essential skill set to become a forensic super sleuth and to investigate the issues that are driving the need for the qualified medical evaluation. And the reason that's more important now than ever before is because for whatever reasons, plural, the parties don't provide us the necessary information. We're not privy to the information which, if we knew, it would make our jobs in providing our opinions and conclusions so much easier. But for whatever reason, we're not provided sufficient and necessary information when we go into the face-to-face evaluation to properly ascertain what are the disputed issues that are driving the need for the evaluation. And so it's incumbent upon you to determine this for yourself. And that's the entire philosophy of this whole program. And in session number 1 of this program, we talked about QME Forms 105 and Forms 106. And those are forms that are used by the parties. Those are not forms that are used by qualified medical evaluators. They're used by the parties to request an appointment with you, the qualified medical evaluator. And on those forms, the parties disclose the disputed issues that create the need for your evaluation. But we don't have access to these forms. We don't get to see these forms. We never lay eyes upon these forms. And so we have no idea what are the issues that the parties invoked in requesting an evaluation with you, the qualified medical evaluator. And I went over with you in session number 1 how those forms create a narrow set of issues, a narrow set of disputes that you need to be aware of. And you need to determine which of those disputes is the dispute that's driving the need for your evaluation. In our second session, we talked about Labor Codes 4060, 4061, and 4062. And we talked about how the compensability exam under Labor Code 4060 is the predominant, type of evaluation that we're now encountering as qualified medical evaluators, especially if you're in Southern California, where there seems to be a glut, an avalanche of denied cases. It's the denied cases that come to us under Labor Code 4060. It's the accepted cases and disputes in accepted cases that come to us under Labor Codes 4061 and 4062. And we talked about how to handle each of those disputed issues. In our last session, we began a fascinating discussion having to do with post-employment claims, and particularly the species of post-employment claims that involve specific injuries, and also the growing population of claims that involve cumulative trauma injuries or claims for cumulative trauma injuries when those claims are filed after the employee has separated his or her relationship with the employer. So these are claims that are filed post-employment for an injury during the employment period. And we started to discuss some of the issues about how to identify these types of claims and how to distinguish between the dates of injury for specific versus cumulative trauma injury claims. And this is the type of claim, especially if you're in Southern California, that you're going to be seeing an abundance of over the next several years. And just to illustrate this point, just today, just before I began this recording, I took in a call myself And it involved a employee filing a claim for both a specific date of injury and also a cumulative trauma period, and the claim was filed after his separation from the employer. So just today, I just took in this exact type of scenario that we're discussing in this series of topics regarding the post-employment claims. Now today we're going to continue on the discussion of post-employment claims, and we're going to talk about Labor Code 3600 and some of the other issues that are involved with handling post-employment cumulative trauma specifically, and also the specific injury types of claims. And these are fascinating claims. They have an exact and specific handling, which if you can get comfortable with the handling of these claims, you can quickly resolve the disputed issues, you can quickly put out your QME report, and you can quickly move on to the next evaluation that's on your desk. So today, let's continue our discussion about post-employment claims, specifically delving into Labor Code 3600 as we continue with our new series entitled the QME Forensic Super Sleuth. Okay, so before we get into Labor Code 3600, I just want to share with you some statistical information from the very latest 2019 State of the System report from the Workers' Compensation Insurance Rating Bureau of California. And this reflects the very latest available statistics in California. So what I want to share with you has to do with cumulative trauma injury claims. And so I have some information specifically on that. Okay, so what we have here is a chart that depicts the growing percent of workers' compensation claims that involve cumulative trauma. And here, the last year for which statistics are available, and these are only preliminary statistics, because many of these claims are filed after the year in which the injury is claimed to have occurred. Not all information on 2017 injuries are yet in, but this is preliminary information which shows a steady increase in the percentage of claims that involve cumulative trauma. So we're now at approximately 18% of all claims involving cumulative trauma. And let's just read some of the notes from this table. They tell us that cumulative trauma rates have doubled from 2006 to 2017, from approximately 9% of all claims to now 18% of all claims. CT claims are often filed much later than other claims, and an even greater proportion of CT claims have been filed later in recent years. And we're going to learn just why these claims can be filed late. Late meaning long after the period of exposure to cumulative or repetitive activities. Finally, additional statistics: almost 80% of these claims are in Los Angeles or San Diego. 90% involve represented injured workers versus unrepresented injured workers. It seems that unrepresented injured workers do not file claims for cumulative trauma. These are all filed by represented injured workers. And 40% are filed following the termination of the employee, or we should say following the separation of the employee from the employer. And these form the basis of what we're going to talk about today, which is the post-employment cumulative trauma injury claims. And then also almost 75% of these claims are initially denied claims, at least in part, meaning that some parts of the claim may be accepted. For example, the claim may be accepted for one or two body parts, but denied for other body parts, as an example. And these are the claims, these denied claims, that come to us under Labor Code 4060. So it's important that you sniff out this information through your review of the intake documents that you receive from the parties, through your review of the medical records, and also you sniff it out in your interview with the examinee to determine what is the big picture of the claim that's driving the need for your evaluation. Now, for those of you that are in Southern California, this particularly applies to you, and this chart shows the percent of cumulative trauma claims by region, with the Los Angeles Basin and San Diego areas represented in blue and yellow respectively. And you notice that in those two areas of the state, cumulative trauma injury claims are on a sharp rising slope on the graph, whereas claims in the Bay Area are declining, and cumulative trauma injury claims throughout the remainder of California are holding relatively steady. But note the sharp increase in claims in Southern California. And the WCIRB tells us that all of the recent increases in cumulative trauma claims have come from the Los Angeles Basin and San Diego areas. And they've done some research as to who it is, what type of demographic statistics apply to these employees that file these claims on such a frequent basis, and they find that the most significant cumulative trauma claim frequency increases in these regions are from workers with weekly wages below $500. So this is the type of examinee that you're going to be seeing in the face-to-face evaluation. These examinees are frequently in the hospitality or in the manufacturing industries. They have weekly wages below $500, and they're coming to you with denied claims, and the evaluation is being driven by Labor Code 4060. Okay, and many of these claims are filed post-termination. So let's talk now about Labor Code 3600, which specifically deals with how to handle claims filed post-employment. Okay, so let's talk about Labor Code 3600, and we began this discussion and some references from Labor Code 3600 in our last session, but just to get all together on the same page, let's just reiterate that Labor Code 3600, in dealing with claims that are filed post-employment, tells us, at least administratively and legally, how these claims are handled. So Section 10 of Labor Code 3600 tells us that where the claim for compensation is filed after notice of termination or layoff, including a voluntary layoff, okay, including employees that say take this job and shove it, or employees who retire, or employees who move on to a different job, okay, voluntary layoff, and the claim is for an injury occurring prior to the time of notice or termination or layoff, right? Prior. No employee is going to file a claim for injury occurring after they left their employment. That doesn't happen. The claim for injury always comes for the period of time when they were with their prior employer, okay? So the claim is for an injury occurring prior to the time of notice of termination or layoff. The law tells us no compensation shall be paid. No compensation shall be paid. No compensation shall be paid unless the employee demonstrates by a preponderance of the evidence that one or more of the following exceptions to this basic rule apply. So let's dissect this here for a moment. It tells us that by law, when claims are filed post-employment, by law, no compensation shall be paid. Now let me ask you, why would legislators and lawmakers create a law that prevents separated employees from recovering compensation from their prior employer? Why would lawmakers find it within their wisdom to create such a law? Why would they do that? The reason they do that. And the reason they did that is because they've been long familiar with employees attempting to retaliate against their former employer for whatever reason. We can speculate on the reasons all day long, whether it be that they are disgruntled, whether that be that they want to strike back at the former employer, whether they even had an actual injury with the former employer, but they neglected to report it timely and therefore they forfeit their opportunity to recover compensation. In other words, whatever the reason, lawmakers have found it necessary to block this particular species of claim, the claim that is filed after the employee is separated from the prior employer, unless a few specific and exacting conditions can be demonstrated. And who has the burden of demonstrating that these exceptions exist? The law tells us that the burden falls upon the employee. The employee. So the employee or the employee's applicant attorney must demonstrate with a preponderance of evidence some of these exceptions. If the employee is unable to demonstrate the existence of one or more of these exceptions, then the claims administrator realizes that this is a claim that can be denied. And this is the type of claim that's going to come to you where the examinee has no way, no support, no evidence, no forms, no documents, no pictures, no photos, no preponderance of evidence, no way to demonstrate the existence of one or more of these exceptions. So you need to be aware of this when you come face to face with your examinee, and you always ask yourself, what is the preponderance of evidence that the examinee is bringing to demonstrate the existence of one or more of these exceptions? Okay, so let's talk about one or more of these exceptions. So one of the exceptions has to do with whether or not the employer had actual notice of the injury prior to the notice of termination or layoff. And this would make sense. So remember, it says, Labor Code 3600 says that no compensation shall be paid unless the employee demonstrates by a preponderance of evidence that one or more exceptions exist. One of the exceptions is Section A, that the employer has notice of the injury as provided under Labor Code Section 5400, and we're going to talk about that in just a minute, prior to the notice of termination or layoff. So we'll go over some timelines also in a minute, but this makes sense. This is what protects injured workers who file claims post-termination. If the injured worker or employee can demonstrate that prior to the date that they received a notice that they were going to be terminated or laid off, if they can demonstrate that before that day they actually provided the employer with notice of an injury, then that injury would be covered even if it's filed post-employment. And that makes sense. That makes sense. What this is this is evidence. This is evidence of the injury. Lawmakers protect injured workers when an actual injury occurred, and they can prove it with evidence. And the evidence in this case is that they provided the employer notice that there was indeed an actual injury. So the gray area involved with this particular exception has to do with what qualifies as notice. And as we're going to see, the range of strength of evidence relating to the notice of the injury ranges from extremely tight and rigid criteria to qualify as notice, all the way to very loose and basically non-existent evidence. And you're going to see how your examinees use a range along this spectrum of strength of evidence in describing the notice that they provided to the employer. And I'll give you some examples as to actual language that you can expect to hear from your examinee. Okay, so let's now go over section 5400 and talk about what qualifies as notice of the injury. So if the employee can demonstrate that he or she provided notice to the employer of the injury, they can provide evidence of the injury occurring prior to the notice of termination or layoff, then that claim can then move forward. So what constitutes notice? Well, Labor Code 5400 tells us that except as provided by sections 5402 and 5403, which we'll talk about in just a minute, except for those exceptions, it tells us that what qualifies as notice is quite tight and restrictive, but there are exceptions to that. So while Labor Code 5400 creates a tight and rigid requirement for notice, there is a backdoor escape hatch under Labor Codes 5402 and 5403, which we'll discuss in just a minute. But 5400 tells us that no claim to recover compensation under this division shall be maintained unless within 30 days, 30-day statute, within 30 days after the occurrence of the injury which is claimed to have caused the disability, there is served upon the employer notice in writing, a written notice within 30 days of the date of the claimed injury, signed by the injured person or signed by someone in the behalf of the injured person. So many claims are denied because the claims administrator contends that the employee blew the 30-day timeline and provided no written notice within 30 days of the date of the reported injury. You see, 30 days within 30 days from the date of the reported injury could be much different than 30 days prior to the notice of termination or layoff. This creates 1,000 different scenarios wherein different dates are described regarding the date of injury in relation to the date of notice of termination or layoff, in relation to the actual date of separation from the employer. And I'll give you a couple of examples of that. But this provides the major out for the claims administrator to deny the claim due to what is referred to as the post-termination defense. This is the post-termination defense that the examinee or the employee failed to provide written notice within 30 days of the date of injury, and therefore the claim can be denied. So these are the claims that come to us under Labor Code 5400, and this one here is referring specifically to specific injury types of claims which occur after the occurrence of the specific injury which is claimed to have caused the disability. Okay, so this is a fairly tight and rigid requirement that places the burden on the employee to provide written notice within a very specific and tight time frame. Otherwise, the claim is barred from compensation, except, there's always exceptions, except under Labor Codes 5402 and 5403. So let's discuss the out clause under 5402 that 99.99% of examinees will exercise. Okay? So under Labor Code 5400, in order to qualify as notice of the injury, remember the employer has to be provided of notice of the injury. Under 5400, notice of the injury is a written statement filed within 30 days of the date of the reported or claimed injury. But 5400 tells us that there's some exceptions to this, and those are described in Labor Code 5402 and 5403. And 5402 tells us that knowledge of an injury, which can be obtained from any source, on the part of an employer, his or her managing agent, his superintendent, his foreman, or any other person in authority, or knowledge of the assertion of a claim of injury, which is sufficient to afford opportunity to the employer to make an investigation into the facts, is equivalent to service under Section 5400. 5400 requires written notice within 30 days. This section tells us that a written notice within 30 days is not the only qualifier as notice of the injury. 5402, let's dissect it a little bit, tells us that simply having knowledge of the injury obtained from any source. So the injured worker will tell you in the face-to-face evaluation that they were injured on the job and they told their coworker, William, to tell the supervisor, and the supervisor obtained the knowledge of the employee's injury through the coworker. This is from any source, from the coworker, from a written note, from gossip through the grapevine, from a phone call, from a text message, from an email, from any source, knowledge of the injury obtained from any source on the part of the employer, okay, the boss, human resources, any superintendent, any foreman. Injured worker will tell you, yeah, I told my supervisor. I was injured on the job and I told my supervisor, but he didn't do anything. But the injured worker is contending, in using this phraseology with you, he's contending that the employer, the foreman, had knowledge of the injury, even though the employee himself did not provide written notice within 30 days as required under Labor Code 5400. So this is a very loose criteria to qualify as notice of the injury, whereas Labor Code 5400 creates a very tight and rigid requirement for written notice within 30 days. This section obviates the need for written notice within 30 days, and it's this section that you're going to encounter 1,000 million times in your career as a qualified medical evaluator, because these cases that we get involve employees that provide no notice. They provide no notice. There is no written notice within 30 days, but they contend that they told someone. They reported it. They verbally reported it. Okay, and a verbal report, a text message, a phone message, a post-it note, I told my son to call, those qualify as knowledge from any source to any party under the purview of the employer qualifies as notice. Any assertion of a claim, any assertion of the claim, the injured worker, the employee, asserts to have an injury, and that assertion allows the employer the opportunity to make an investigation into the facts, is equivalent to service under the more strict requirement of Labor Code 5400. And you're going to encounter this all the time. So be aware of this particular exception to the provision of notice. And it's this exception that can allow post-employment claims to fly, even though Labor Code 3600 generally bars post-employment claims. Okay, and then very briefly, let's take a look at Labor Code 5403. And then Labor Code 5403 tells us that the failure to give notice under Section 5400, the failure to provide written notice within 30 days of the date of claimed injury, or any defect or inaccuracy in a notice, in other words, even under Section 5402, any defect or inaccuracy in testimony, any contradiction in the testimony, any conflict within the testimony, any defect or inaccuracy in a notice is not a bar to recovery under this division if it's found as a fact in the proceedings for the collection of the claim that the employer was not in fact misled or prejudiced by such defect or failure. Now, I don't know exactly what that means because I'm not a lawyer and I'm not sure exactly how we as qualified medical evaluators encounter this particular provision in the law, but what I surmise from this is that this, in conjunction with the exception provided under Labor Code 5402, creates a very loose situation whereby almost anything can qualify as notice, as employee notice to the employer of the injury, thereby creating a very loose loophole that can be exploited under Labor Code 3600, where injured workers will claim in their filing of claims post-employment, they will claim that they told their supervisor, that they gave a written notice, that their son called human resources, or in some other way they provided notice of the injury, because it's the provision of notice that allows the claim to move forward. Otherwise, the claim is barred by Labor Code 3600. So let's just give an example of a case scenario whereby this particular provision would be operative in your particular examinee. Okay, so as an example, remember that no compensation shall be paid unless the employee demonstrates by a preponderance of evidence that the employer has notice of the injury as provided under Section 5400 prior to the notice of termination or layoff. So imagine this. You have an employee on November 15th. Let's focus on this middle box here. You have an employee on November 15th who receives notice of termination or layoff. And the notice of termination or layoff tells them that on December 1st, that will be their last, that will be the day of their first day of no more working for the company. As of December 1st, they will effectively be laid off, okay? Well, the earliest the employee can claim injury would be October 15th. The employee cannot claim injury earlier than October 15th, say for example September 15th, because September 15th is beyond 30 days as required by Section 5400. So when the claims administrator receives a claim for industrial injury for a date of injury, say for example September 15th, the claims administrator looks at that and they realize that the date of injury is more than 30 days prior to the notice of termination or layoff, and they simply deny the claim under Labor Code 5400, which requires a written notice signed by the employee. But why these cases come to us as qualified medical evaluators is because the employee will contend that they provided notice under Labor Code 5402 in that the employer obtained knowledge from any source, from any other party, of the injury. And you'll hear this in the face-to-face evaluation when examinees tell you that they told their supervisor, or they filled out a form in the office, or they told the secretary, or they left a voicemail message asserting a claim for industrial injury. See, there are direct methods of providing notice, and the direct method is under Section 5400, which is a written notice signed by the injured employee. That's a direct method. The indirect method, the passive method, is to contend that the employer had knowledge or assertion of the claim, and that's what allows these claims to escape the so-called post-termination defense. Okay? So let's look at another exception or another escape hatch that allows these post-termination claims to move forward under Labor Code 3600. Okay, so the exception under Labor Code 3600 Section A has to do with the employer's knowledge of the injury, or the employer being provided notice of the injury. And that makes sense. In this sense, the lawmakers have protected injured workers who have actually had an injury prior to the notice of their termination or layoff, but haven't made a deal about it, haven't requested medical treatment, haven't requested time off work, or what have you. But the purpose of having exemption A under Labor Code 3600 is to protect injured workers who have actually provided notice, who have actually suffered an industrial injury. Well, exception or exemption B is similar. It's in place to protect injured employees who actually have suffered an industrial injury but did not file a claim for industrial injury until after they separated the relationship with the employer. So this exception has to do with those cases wherein the employee's medical records existing prior to the notice of termination or layoff contain evidence of the injury. And doesn't that make sense? If you have an injured worker who receives notice of termination or layoff on, say, for example, November 15th, and the first day of layoff is December 1st, and they file a claim for injury after December 1st, they file the claim, they file after December 1st, and they claim an injury that occurred prior to the date they received their notice, which is November 15th, if the medical records from their private health care insurance, the local urgent care, the chiropractor, massage therapist, what have you, if those medical records that exist prior to the date at which they received notice of termination or layoff, if those medical records contain evidence of the injury, then this claim can move forward and this employee can be eligible for workers' compensation benefits, even though the claim was filed after separation from the employer. And I recently had just such a similar case. I had a 35-year-old beautician. She was a hairstylist at a national chain. And after she left employment with the national chain to move on to open her own business doing the same type of work, cutting hair in a similar type of salon environment, but after she separated from the national chain, she filed a claim for cumulative trauma injury. And don't you know that her medical records, even in the 1 year preceding her last day of work with the national chain, talked about her symptoms and how her symptoms were aggravated, perpetuated, and even initiated by the workplace activities with the national chain. So when the medical records evidence the injury, it only makes sense that the claim should move forward. So when you have these post-employment claims, you may or may not be provided with medical records prior to the date of the claim or of the date claimed of the injury. You may or may not have medical records that precede the claimed date of industrial injury, because upon whom does the burden fall to prove that the medical records contain evidence of the injury? The burden of proof falls upon the employee, does not fall upon the employer. And so the employer has no incentive to obtain these medical records. The employer has every incentive to not pursue these medical records, not request these medical records, not subpoena these medical records, to disappear these medical records, because according to the law, the burden falls upon the employee. So you, as the qualified medical evaluator, can expect these records to not exist unless somehow, some way, they've been procured either by the applicant attorney or by the injured worker and then administered into the record by one or the other of those parties. Don't expect the claims administrator to be motivated to dig for the employee's prior medical records because the burden falls upon the employee. Okay, so doctors, I want to conclude today's discussion here at this point. We're going to continue in our next session with more exceptions under Labor Code 3600 that allow post-employment filing of claims to carry on and to become eventually accepted claims. But in general, Labor Code 3600, the post-termination defense bars such claims. Well, why are we then getting so many claims for post-employment specific and cumulative trauma injuries? And that is because of the exceptions. Because exceptions exist and our employees or examinees are claiming that they fit into one or more of the exceptions, thereby demanding that the claim move forward. So this is important administrative information for you as a qualified medical evaluator to know, to understand why you're getting this claim in the first place and what are the issues behind the denial of the claim under Labor Code 4060. And therefore, once you understand these issues, you can understand your role as a qualified medical evaluator, and you can understand what it is specifically that you're being called upon to resolve in the opinions and conclusions sections of your report. So doctors, I hope this helps you. This particular scenario is a scenario that you're going to see 8 out of 10 in your very next evaluations. So it behooves you to become familiar with these labor codes and with these laws and with these issues that surround these claims. And if you can become familiar and fluent with these issues, you can very quickly and easily wrap up and solve the disputed issues that the parties call upon you to do. Okay, so I hope this helps you. And I want to thank you for taking the time to join me on today's discussion. Look forward to being with you in our next discussion as well as we continue on post-employment claims in our new series entitled The QME Forensic Super Sleuth. This is Dr. Perry Carpenter wishing you best of success in your career as a qualified medical evaluator.